Welcome. I'm Jerry Oginski, a medical malpractice and personal injury trial lawyer practicing law here in the state of New York. Today's topic is accidents, 5 deadly sins that could sink your accident case. Number 1, the lawyer refers you to a doctor. Now, while there's nothing inherently wrong with that, there is a problem because the client, the client, may not realize that the lawyer has referred other clients to this particular doctor. And when we go into court, the jurors may not recognize the doctor because they may not have seen him multiple times. The lawyers for the defense, I guarantee you, have seen him many, many times. And the judges have seen the doctor many, many times. And it's not to your benefit to have the attorney recommend a particular doctor for you, because what will happen during cross-examination by the defense, they're going to bring out the fact that this lawyer has recommended clients to this particular doctor many times. And not just this lawyer, but many other lawyers refer clients to this particular doctor as well. Because if he testifies well and he gives them information that they like and is favorable to them, other lawyers are going to start using him too. So when a lawyer refers a client to the doctor, many people will call this the kiss of death. And you don't want to have this problem at the time of trial. There are enough legal issues that will arise during your trial that this should not be one of them. I often will tell a client, if you have problems and you're not comfortable with the doctor that you're seeing, go to another doctor. Get a referral from a friend or relative and do it that way. Number 2, hiding past accidents from your lawyer. That will sink your case, clearly, without a doubt. If you don't tell your lawyer about everything that's gone on in your past and in your history, you are tying your attorney's hands, because what will happen is that he will get sandbagged during the course of your deposition or at trial, which is even worse. If your attorney doesn't have the information necessary to prosecute your case properly, you're not going to have effective counsel, and you really don't want to be put in that situation. It's really very detrimental to your case. Number 3, if you hide other injuries, you are sinking your own case. Let's say something happened to you 10, 15 years ago, and now you are claiming that you suffered a similar injury or an exacerbation or aggravation of that injury. But you neglect to tell your lawyer about an accident that happened to you many years ago. And during the course of investigation, your attorney finds this out, but it's too late to do anything about it. The worst is when the client does not tell the lawyer that they've had a similar accident causing similar injuries in the past. And now at deposition, the defense lawyer asks the question, well, Mr. Jones, have you ever been involved in any other accident? If you say no, and it turns out that you were, and they learn about that accident, I guarantee you they will, your case is just as good as over as anything else. It's gone. Where you lie, your case is finished and you've sunk your own case. You've got to tell your attorney what happened to you about your injuries in the past and any accidents you had in the past. Only by doing that can your lawyer properly prepare you on how to answer the questions properly. No hiding things. Be forthright and be straightforward about what happened to you, and you should not have a problem. Number 4, not having accurate tax returns can get clients into a lot of trouble. When you claim that you've suffered as a result of your injuries and you've been out of work, if you do not have accurate tax returns, they are going to bring it up as an issue of credibility. The defense lawyers will turn on you and show clearly that you have lied about things in your taxes. And if you've lied about one thing, what's to say you have not lied about other material things going on in your case? It's devastating. Shouldn't happen. If you have problems in your tax returns that need to be corrected, make sure you contact your accountant, fix it up, and deal with it. Don't leave it for later on, because it'll come back to haunt you. Number 5, misrepresenting your activity level. When you are injured and you say you cannot do all the things in your daily activities that you claim you cannot do, what will happen is that sometimes defense lawyers will hire investigators to go out and take pictures or video of you. And if you claim you can't play basketball, if you claim you can't do sports, you can't change a tire, you can't go to the gym and work out, and somebody gets you on video doing those exact activities that you claim that you could not do, your case is finished and over. You just better make sure that your attorney doesn't know about it, because once he learns about this improper activity level, he's going to ask the court to withdraw as your attorney, because he can no longer continue to ethically and morally represent you and prosecute your case. So please, do not represent your activity level. If your injuries are minimal, come right out and say they are. Don't overstate exactly what it is that you're claiming. It's better to understate your case and let the jury know that you're trying to do your best in overcoming your disability, and you're not one to sit at home and try and live off the fat of the land and wait for your case to, hit the jackpot, as we've talked about in previous videos. Don't do it. Try and make the best of your life. Try and go back to work. Do the best that you can with whatever injuries you have. And that's all for today. Thank you for joining me. I'm Jerry Oginski. Have a great day.